Okay, good afternoon, everybody. My name is Joseph Dickey, and I, along with Katie Busbee, are here for our Haynsworth Sinkler Board mid-year employment law legislative update. You could be a lot of places today eating lunch, but you chose to spend it with us. And for that, we are grateful. We're going to try to jump right into this. We have a lot to cover, and I'm sure there are questions that we're going to address. So let's get into it. Obviously, the introduction. Haynsworth Sinkler Boyd's full service law firm. We have over 115 plus attorneys across 2 states, 5 locations, able to handle your legal needs. If you have questions, please submit them. We'll try to address them. And this PowerPoint will be shared with you after the presentation, well, after the webinar. All right, today we're going to try to go through things starting with federal updates. I know everybody's probably heard of the 3 updates we have listed there with non-compete rule that's pending, the Pregnancy Workers Fairness Act, and the DOL overtime rule under the Fair Labor Standards Act. I'm going to try to hit some trending issues. A lot of that is going to cover some of the recent union activity that's been going on, and then we'll have a brief South Carolina update. There haven't been any real profound or major things from a state law perspective that have occurred this past year that will impact employment law, but there are some things we just want to at least make mention of. And with that, we're going to jump into the non-competes. And Katie, with mine, let's get to it.
Okay, so I know that we did a presentation on this a few months ago when we went into a lot of the details, but really, I mean, this is something that we've been getting a lot of calls on, and knowing how to navigate this rule until it goes into effect. And so we wanted to be sure to cover it today. So just to give a brief overview of the FTC rule. So it does prohibit employers from entering into a non-compete clause after the effective date. And a non-compete clause is any term or condition that prohibits a worker from seeking or accepting work in the U.S. with a different person or operating a business in the U.S. And so after the rule goes into effect, you aren't able to enter into any type of non-compete clause. You can still do confidentiality clauses. You can still do non-solicitation clauses. You'll just want to reach out to us. Let us take a look at those. Some people's non-solicitation clauses go pretty far and almost function like a non-compete. I've reviewed a couple lately that we've made some changes to. Those are still, you can still do non-solicitations, but we want to make sure that they are enforceable with this rule. It also requires you to give notice to all of your employees that have a non-compete, and you have to provide them notice that basically says, we will not be enforcing your non-compete. And there is language in the FTC rule. There's like a draft notice that you can provide to your employees. And there's a safe harbor provision that basically says, if you provide this notice, this complies with the requirements of the rule. And it also prohibits you from enforcing past non-competes unless that non-compete is with a senior executive. And we'll talk a little bit more about that. So just broadly, you can't enter into new non-competes after the effective date. You have to notify your workers that do have a non-compete that you can't enforce it. And then you can't enforce prior non-competes unless it's with a senior executive. Okay, next slide. So there are a few limited exceptions under the rule. The first being if it's a bona fide sale of a business. So if a non-compete is a part of, a purchase agreement or something like that, where a business is being sold or someone is selling their equity in a business, or substantially all of the assets in the business are being purchased. Non-competes can still be entered into in those situations, and they are still enforceable. Even under South Carolina law, and I think a lot of state laws, courts are much more willing to enforce non-competes when it's in conjunction with the sale of a business. And, that makes a lot of sense. If someone's purchasing a business, they don't want that seller to be able to go out and set up shop close by and basically compete with them. And so that's still going to be allowed after the rule goes into effect. The second exception is if the cause of action for the breach of the non-compete accrues before the effective date, you can still enforce that non-compete after the effective date. So your employees that currently have non-competes, if they breach those before the effective date, you can still bring suit after the effective date because that cause of action has already accrued. So be aware of that as well. I think there might be employees out there under the assumption that when this rule got announced, it's like the Wild West and they can go do whatever they want. And that's not the case. So there's also a good faith exception that basically just says, you can still enforce a non-compete if you feel like this rule does not apply. So again, if you have a senior executive, anything that this rule does not prohibit, as long as you have a good faith belief that the rule doesn't apply, you can still enforce those covenants. So a few exceptions there. And then I also want to talk about the next exception, dig in on that senior executive exception a little more. Next slide. So I've gotten a few calls about this as far as how senior executives are defined under the rule and how potentially expansive this could be. And so again, it's good to make this distinction. These are non-competes that are entered into prior to the effective date. So after the effective date, you can't enter into a non-compete with the senior executive. So these are agreements already in place. And they have to be in a policy-making position, and they had to have made that number right there, a little over 151,000 in total compensation in the preceding year. And again, annualized if they worked, for part of the year. But, the rule discusses that this exception is really meant to be for your C-suite people, your highest level people in the company. And the way the definitions are set forth as far as policy-making position and policy-making authority, there doesn't seem to be a lot of flexibility in these definitions and these rules. So these truly should be just a handful of people at your company, your C-suite people, your highest level people. And so the rule defines policy-making position as your president, CEO, any other officer position, or someone similar that has policy-making authority. And so policy-making authority is whether that person has final authority to make policy decisions that control significant aspects of the business. So these are not people that may weigh in on policy decisions or have a seat at the table. This is someone who has that final authority to be able to make the decision.
And Katie, I want to interject if I can. I want everybody to notice, the number, the threshold of 151,164, I believe is the same number that is going to be the new high compensated employee threshold for the FLSA salary rule or overtime rule once we get into that. And I want people to kind of understand the distinction Katie is making. When you start looking at the non-compete, if you have a senior executive making this salary and in a policy-making position, you might can still have this non-compete. However, you can have a highly compensated employee under the DOL overtime rule who isn't in a policy-making position, who still will meet the qualification for FCE because they're making at least the threshold of the 151,000, but they won't be subject to the non-compete. So I just want to point that out and make sure we understand that distinction, even though it's the same number.
That's perfect. Thank you, Joseph. Yes, so these are your very high level people. And the rule also discusses that these are not people that have final authority over a subsidiary or affiliate. These are people that are, in your C-suite over that actual organization. So again, probably a very small group of people. And a lot of the comments to the rule, I think they really are intending this to apply to very few people in your company. So I don't feel like it's something that, there's going to be a lot of stretch to, if that makes sense. Okay, so next slide. So this rule is set to go into effect September 4th, unless, there are a lot of lawsuits out there challenging the rule currently. And so, we could see some type of injunction that delays that effective date until courts can figure out, whether this rule is going to stand. Could go all the way up to the Supreme Court. We don't really know. And so, the effective date is September 4th, but there are some things that could happen in between now and then. And so this really puts a lot of employers in just kind of a pinch spot of, what should we be doing now? How should we be preparing, if and when it does go into effect? So next slide. So again, we've been getting a lot of calls on this, and I think, you kind of have to make a decision of what you want to do in this interim period. You can still enter into non-competes currently. So, I mean, the September 4th date has not hit. You can still require candidates and new employees or existing employees to sign a non-compete. But just understand that after the effective date, if this rule does go into effect, you won't be able to enforce that. Unless it's a senior executive. And you also are going to have to provide that employee notice. They're going to have to go on that list of being provided notice that their non-compete is unenforceable. And so, I'm having some employers that still want to make employees sign these for now, just because it is uncertain about what's going to happen with this rule. I have gotten some calls where the candidate is refusing to sign this because they say that there's a new rule where they don't have to. So I think you probably have to weigh, is it worth, from like a recruiting standpoint, is it worth to make them sign right now? Is it that important that you have a non-compete in place? And so, we've been telling employers for years, because non-competes have always been disfavored by courts, that, most of the time a good confidentiality and non-solicitation provision can accomplish what you're looking for. And so you'll just kind of have to make that call. Is it worth it, to try to make them sign before the effective date? And it might be. So you also want to take stock of who has a non-compete currently in your company. Start making a list of those people that you're going to have to provide notice to. And, as we get closer to that September 4th date, you are going to have to provide notice before that effective date that their non-compete is unenforceable. And so I know I have a little tickler on my calendar for early August to circle up with our employers that have reached out to me to start try to make plans for that. Again, that date could be delayed. We're just not sure, but you want to be in a good position where you're ready to pull the trigger and comply with the rule if it does go into effect.
And some of the things we have been doing with some of the clients that have reached out to me have been just taking some of the non-compete we have and just reviewing it and making some revisions already. I think we like to say look at it on the front end instead of trying to deal with it on the back end if at all possible, or at least getting prepared. Just as Katie was saying. So if that's something you would like to do, feel free to reach out to us.
Yep. Okay, I'm going to go through this and I'm gonna let Joseph kind of interject too, because I know he's had some calls from employers on this, on the new EEOC regulations for the Pregnant Workers Fairness Act. And I know Chris probably 4 or 5 months ago did a really in-depth dive on the Pregnant Workers Fairness Act. But the EEOC regulations actually just went into effect this month. So okay, so this applies to employers with 15 or more employees, and it closely tracks the language of the ADA, although there is a good argument that it's much more expansive than the ADA, and we'll kind of talk about that. But it requires employers to provide a reasonable accommodation to a qualified employee or applicant or their known limitation relating to, affected by, or arising out of pregnancy, childbirth, or a related medical condition. So this, related medical condition, it can be much broader than just like your normal pregnancy issues that are very commonplace. Basically anything that could come up and be related to pregnancy or childbirth or any post issues after childbirth. It can be very expansive. So just be aware of that. It can cover a lot more than might be on the surface. And it applies to mental and medical conditions, So similar to the ADA in that way that it covers mental conditions. The limitation does have to be known to the employer and that it has to be communicated to the employer. There, just like the ADA, there are no magic words that they have to say. So the employee doesn't have to say, I need a reasonable accommodation. But they do have to communicate whatever issue they're having. They have to put the employer on notice that they're having some kind of limitation. There is this reasonable, or there is this undue hardship standard like there is under the ADA. So an employer doesn't have to provide an accommodation if it causes an undue hardship. So I will say, I think one of the things, and Joseph and I were even discussing this a little bit before the call or the webinar, one of the areas that this is potentially much more broader than the ADA is how the Pregnant Workers Fairness Act defines a qualified individual. There's language in the rule that talks about if the employee can't perform the essential functions of the job with or without the accommodation for a limited duration, or I think it says a temporary period, or if they're going to be able to perform the essential functions of the job in the near future, then you have to go through this interactive process to reasonably accommodate them. And that's a little bit different than the ADA. Under the ADA, if you can't perform the essential functions of the job with or without an accommodation, most of the time when we're talking to employers at that point, if they're not able to have an accommodation at all, we're a lot of times looking at termination. But under the PWFA, if they could perform that essential function after pregnancy or sometime in the near future, and those terms aren't really defined under the Act, then you're going to have to reasonably accommodate them. You're going to have to find some kind of accommodation and work it out with them. And so it's much more expansive than the ADA in that way. And so just be aware that, if you have an employee that's like out on maternity leave, or they've come back after maternity leave and are having issues, and you're needing to discipline them or terminate them, even if it's justified, I would give us a call and just let us, kind of help you walk through that, just because this is such a minefield for employers right now.
And let me piggyback on some of that with what Katie said. When we're looking at accommodations under the PWFA, let's talk about leave being an accommodation. So this applies to employers with 15 or more employees. So you could theoretically be an employer who's not covered under the FMLA, and your handbook could say, we don't provide medical leave or job protected medical leave under the FMLA because we don't have 50 or more employees and meet all the standards under the qualification under FMLA. But you do qualify as a covered employer under the PWFA, and leave or maternity leave might be a reasonable accommodation. And so then you might have a question, okay, well, how long must I provide? Must I provide that with pay? Can I require pay? Them to use their sick leave or anything with that? Or, do I have to return them to their job? All of this is kind of vague right now. Well, minus the pay part, because you cannot require them to use their sick leave contemporaneously with the leave that you provide under accommodation. But so that needs to kind of, keep that in the back of your mind, because if you apply that medical leave, let's say you grant that leave, that maternity leave as an accommodation, depending on how you do it, what words you use, how you phrase it, you could possibly voluntarily put yourself up under the coverage of the FMLA under a stop argument, which these arguments are made in federal court and they are successful. And so if you're providing the maternity leave or any kind of leave in connection to the pregnancy or any accompanying issue, be careful on how you do it. Be mindful. Please give us a call so we can kind of walk through it, because we don't want to do it, especially if you're an employer who is not covered under the FMLA, is to somehow voluntarily get you covered under the FMLA. And now you have yet another federal law that you have to contend with.
Perfect. Thanks, Joseph. Okay, I think we can go to the next slide. So these are just some examples of accommodations that are listed under the regulations of the PWFA. very, I would say, like common sense, and a lot of the same accommodations that are also evaluated under the ADA. So, you know, more breaks, changes to dress, change to work schedule, teleworking, reassignments, temporary suspension of one or more essential functions of the job. That kind of goes back to what I was saying earlier. So, you know, the regulations do provide some workable accommodations for employers to consider. Next slide. So the PWFA does have some restrictions as far as how much information you can seek from an employee's healthcare provider. So under the rule, you can ask for information from their healthcare provider if it's reasonable to do so. And the EEOC has basically said it's not reasonable if their limitation is obvious, and if the fix is obvious. You know, if it's something like they're obviously pregnant, they may need to take more breaks or sit down to do their job, things like that, then the EEOC would say that that's unreasonable to then require certification from their doctor or information from their doctor giving their limitations and accommodations. So you also have to be careful about the situations where you are asking for information from their healthcare provider. Again, if it's something, if they have an obvious limitation and it's an accommodation that's obvious, then those aren't situations you should be asking for health provider information. You are also limited in what you can ask from their healthcare provider. So you can only ask them to confirm the condition relates to, arises out of, or is affected by pregnancy, childbirth, or a related condition, and then describe the adjustment that's needed due to the limitation. And so this is pretty narrow. And I would say that most of the forms that we worked with employers, even on the ADA side, are usually limited to these types of things. But, you know, this is specifically set out in the regulation. So you want to make sure that your communications with the healthcare provider are only these items. And then you also have to keep that medical information confidential and separate, just like you would any other medical information. Joseph, do you have anything else on that?
No, but I think it would be a good time for us to kind of possibly take some questions. I think we got two, if I'm looking right, and I'll read them out. The first one is concerning non-competes. If a candidate signs a non-compete now, but their effective date is on or after September 4th, 2024, would the rule actually apply from an employer's point of view? And so, Katie, I mean, I think you're still in the same boat as you would be in regardless, because if they signed it now and it's not effective until then, you're still looking at that non-compete, and you still know what's in it. And so if there hasn't been an injunction come mid-August, early to mid-August, I think you still send a notice. I think the best course would be right now is to kind of make sure you have the appropriate non-solicitation, confidentiality provisions in there, and have your other boilerplate provisions in the agreement that says if a provision in the agreement is deemed unenforceable, it knocks out, but other provisions will last. And, you know, keep moving. I think that's the best way to handle it, or just risk it. But I would prefer you to have the non-solicitation confidentiality in there. Katie, what are your thoughts?
Yeah, I mean, I agree with that. I mean, technically, if the effective date of the agreement is 9/4, you know, those provisions would be unenforceable, and it would have been entered into, it would have been effective after the effective date. So I think I would, you can still have them sign it, but I agree with Joseph that you need to provide them notice if we start getting close to that date, that it's going to be unenforceable, and you want to make sure you have other strong protections in there with your non-solicitation clauses.
All right, and we got a second question concerning the PWFA, and I'll read it out. Does the PWFA apply to miscarriage, and if so, to both the mother and father?
So it definitely applies to the mother. If there's any issues with the miscarriage, yes, that's a known limitation related to pregnancy or childbirth. The father, that's an interesting question.
Yes, and I did a quick kind of Google, and I've found some I guess advice or consideration that it might include fathers who have given birth or parents to be. And so that at least that's what I'm seeing. But that's a interesting, interesting question. And um, based on what I'm seeing, it looks like it potentially it could. But the miscarriage definitely, just as Katie said. Um, just had one that requested days to care for the mother. Okay, that's what I guess the follow-up to that question was. There was a situation where a father requested days to take care of the mother who had recently had a miscarriage. Uh, so without that's something we can definitely run to the ground and follow up with everyone on. But it looks like just from brief review it that it's potentially it could on a lot of levels. All right.
Okay, looks like we've got a couple more. We have agreements for confidentiality, non-disclosure that can limit the employee from using our process and procedures if they are employed by another company. These are not non-competes. Since it does limit a former employee, does that limitation have any risk of being treated like a non-compete? So your confidentiality, non-disclosure provisions are still enforceable. I would say let us still take a look at them, but typically the confidentiality provisions don't go so far to
Right.
edge up on that non-compete. Usually it's the non-solicitation clauses that do, from what I've seen.
Right.
But I think it's still worth it to reevaluate. What do you think, Joseph?
Yeah, it's always good to reevaluate. It's cheaper on the front end to look at it instead of getting into a dispute. What it sounds like from that question, we're trying just to protect trade secrets, which that isn't anything that the FTC rules contemplate and restrict them. Obviously, as a company, you want to protect your trade secrets. But in the abundance of caution, please let us have a look, just to be sure, so you don't have to get into a situation just in case you have to start fighting someone with an attorney on the back end.
Okay. So it looks like we currently award additional PTO time based on pregnancy. We use any PTO to pay up to 40% of the wages. The remaining 60% is eligible for short-term disability. Does the PWFA restrict this approach?
It seems I'm trying to make sure I understand the question. The PWFA does restrict you from having your PTO time run concurrently with any leave that you provide as an accommodation. But the employee can choose to have that, but you cannot require it. There's a distinction there. Um, so I guess you could use it if they choose to do that. But as long as they choose to do that and that's something you agree upon, I think you probably would be okay. But we can run that down. Mhm.
I just had one that requested days to care for the mother.
Yeah, that was the follow-up to that.
Okay, oh, sorry, okay.
Yeah. All right.
Looks like Chris has a response. Um,
For the father question,
yeah,
I think the dad caring for mother would be entitled to a parental leave or other leave policy, but maybe not a right under the PWFA. Whereas the dad who is the mom or parent who is staying home with the adopted child will have the same rights as the pregnant mom will have under the PWFA. And that's kind of similar to what I've saw briefly as well. So yep.
okay, so I think that's all we've got at the moment. Um, Okay, so we will move on from there. Okay, so what to kind of do on the PWFA, what else to be aware of? As with any kind of law, make sure your supervisors are aware of the PWFA, that they are aware that, employees that communicate a known limitation. And again, even if it's something that isn't on its face, something that you associate with pregnancy, they need to know how to be able to recognize that and respond to it and funnel it to HR or, the appropriate outlet. Your supervisors are always like your first line of defense. They're a lot of times the ones that make it or break it for you, because they're a lot of times the ones that are being notified first. So make sure they are trained.
And I want to piggyback on that. This is a huge issue. We should have probably bolded this and underlined it and highlighted it. This is an issue that I run into often. The supervisor, frontline supervisor, will have information about employee, and it doesn't get to HR a month later, or more. And by that time, we're in a predicament. And so the more we can ensure that the supervisor are aware, hey, come to HR, let us know. Even if you're unsure, there's nothing wrong with just shooting a quick email or something to say, hey, this is what's going on. So that at least we can kind of address the situation if need be, or say it's okay, we can move on.
Yep. Okay, and again, workers don't have to use specific words to request an accommodation to kick off that interactive process. The limitations can be minor again, or they can be something regularly thought of. And accommodations can change throughout, pre-pregnancy, during the pregnancy, when they come back. They may require different accommodations throughout to be able to perform their job. And so just be aware of that can change through the process. Okay, next slide. Go ahead, Joseph.
Now we're coming into the Fair Labor Standards Act, new salary rule. We did a webinar on this back in April, and it hasn't gotten any simpler, and we haven't gotten that much more clarity. But hopefully, come Monday, we'll have clarity one way or the other. As the new rule will, at least the first part of the new rule, will go into effect on July 1st. And so what this is a new rule promulgated by the Department of Labor that's done usually every 3 to 4 years in line with presidential elections to raise the overtime salary threshold, i.e. Raising the amount that you have to make to be exempt from overtime. And so currently that threshold is $35,568. If you make that or more, you are an exempt employee. If you make below that, you're a non-exempt employee, i.e. meaning the employer has to pay you time and a half overtime pay for all work over 40 hours a week. Come Monday, assuming nothing happens, that salary threshold is raised to $43,888. Or I think $844 a week, however the math will compute. So in doing so, what employers have been doing, at least when they're contacting us, is we're identifying those exempt employees who are going to be affected by this rule that's going to go into effect potentially on July 1st. And reviewing the job descriptions, reviewing their duties, reviewing our budgets, and seeing, all right, how do we need to address this situation in case the rule goes into effect? Are we going to make any salary adjustments? Are we going to make any job description revisions? What are we going to do? And we've been working with some of our employers on that on the front end, governmental, public, and private. And it can be tedious, but it is helpful, and it also allows you to kind of look at other things as well. So it's not exercising futility or just a limited exercise. In doing so, you start seeing other things you might want to look at. And so that's the first part of the rule. That's July 1st. Now there are currently pending lawsuits in Texas. I think all of them are challenging this rule. Just as they are all filed every time a presidential election comes about, and they try to raise it. These federal lawsuits are filed and they are pending. Right now, they're just kind of sitting there, but it is the 27th. We have the rest of the day. We have tomorrow. We have Saturday, we have Sunday. Not that anybody's going to court on Saturday and Sunday, but an order could be issued. Who knows? So if we get through the weekend, then come Monday, 43,888, 844 a week. That's the new threshold, everyone. That's it. So it right now it looks like that's going to be our new salary threshold under the FLSA from the Department of Labor. Now, 6 months later, there's going to be another increase, and that's a big one. So it's going to go up to the new salary threshold will be 58,656. Now, to look at that, in months from May 1 to January 1, May 124 to January 125, you're going up over $20,000 for your salary threshold. That's going to affect even more employees. Our advice to employers has been to look at all employees. Look at your cutoff at the 58,656 level, so you can start looking at your changes wholesale, so to speak. In case the January 1 rule also goes into effect. Now, there's a lot more time before January 1. There could be more things that occur, injunctions that could occur. But at least you're on the front end of it and at least looking at it. Even if you don't make the change for those employees that may be affected on the January implementation, at least you have them identified and know what you're looking at as we get closer. All right, there we go. Next slide. Yeah, and just like I said, the second increase goes into effect unless an injunction happens. And I am not Oprah, despite maybe my wants of her success. But I think these injunctions, should they get ruled upon, will be given out the same way she gives out cars and whatnot. Back in the good days when she came on at 4 o'clock. Now I'm dating myself. Y'all don't judge me. So impact and kind of what we see, and I've kind of talked about it. We just need to prepare for July 1. I mean, if you haven't prepared for July 1, give us a call. Let's start working on that. Let's start working on that ASAP, so we can kind of address that, because otherwise, potentially, you could see yourself paying a lot of overtime next week. So hopefully, let's give us a call so we can start working on it. And we will go through the kind of the next 3 bullet points of what, and trying to evaluate what's best for you as an employer to comply with the pending rule that's coming into play. Now, let's say tomorrow, or let's say as soon as we get done with the webinar, an order becomes in place stopping everything. Then you can either go back to your status quo or keep what you've already had the changes you already made. If you've already made changes, my advice would be to kind of keep them, because at some point a rule is going to come in. I mean, it might, if they block the rule for that's coming in for Monday, I mean, they might not get over block January, or it's going to come up again. So you might as well just keep your changes. But it's coming, and Katie, you can kind of chime in on this. In my opinion, I think this is probably one of the biggest things to look at this year for employers, because of the impact it's going to have on, I would say, every aspect of your operation, from your recruiting, hiring, terminations, if you're doing restructurings, assignments, everything. It's going to affect your bottom line revenue. So I think this overtime rule is probably one of the most impactful things that is occurring in employment law that's going to affect employers this year.
Yeah, I agree. Especially that January 1 increase. That's just a huge jump. It's going to affect a lot of people. So yeah, I agree.
All right. And this is a little lunch joke, but just to keep in mind, when our normal office hours are over, there's always time and a half for you. And just like your employers will tell you, they always have time and a half for you as well. There's been these little YouTube shorts with the employee-employer interactions, and it's kind of the same thing. Think of that when you think of making these changes. All right, next slide. These are some trending issues that Katie and I will kind of just chime in and talk about with everyone. The first of which talks about unionizing in South Carolina. And this has been something that's been going on, I'd say, for the past couple of years. I know people have probably seen different news stories, whether it's be for public transit workers or restaurant workers. But Starbucks has been big in this. A lot of the baristas at the Starbucks around, and whether it's Columbia, Newberry, have been starting to unionize. And now I think, let's say the Newberry, Wilson Road, Newberry locations, the 6 Starbucks location unionize. And they're part of the new union, Starbucks Workers United. And they are growing. They are serious. And the NLRB, National Labor Relations Board, they are taking this very seriously, and they are recognizing these unions. And even as we continue to talk today, this is something that's also been becoming more prevalent as time has passed, as the National Labor Relations Board accepting private cases for violations of unfair labor practices under the National Labor Relations Act from employees of non-unionized employers. So while this doesn't apply to you because you don't have a union now, you could, or an employee who, and you're not unionized, could file a claim against you under the NLRA with the NLRB instead of going to the EFC. So it's something just pay attention to. I will say from experience in addressing some of these things, if you get a complaint from an employer, a labor charge, an unfair labor charge, call us ASAP. We need to address that immediately and try to resolve it, work through it. What we don't want is the NLRB coming to make a visit to us. Next slide. I think we're talking about EEOC suing employers for failure to file an EEO1s. I think that's a July 1 deadline. So I think that's Monday. So if you are an employer that has EEO1s, I hope your AAP, DOL attorneys have everything they need so you can meet your deadline. Because I believe the deadline is July 1. If anybody knows for sure, please correct me. But I believe it's July 1. But the EEOC is starting to pursue employers for failure to file these EO1 reports that are mandatory and talk about the demographics of your workforce, where race, sex, ethnicity, those type of things. I thought it usually applied to federal contractors, but either way, just know that the EFC is starting to file suit for your failures to file or submit mandatory reports. Next slide, we're looking at the U.S. Chamber is suing OSHA. And this is challenging the new walk-around rule that was published in April. It took effect in May. The regulation is allowing for third-party representatives of employees to accompany OSHA inspectors during the course of their inspections. So just look at this in reality. You have let's say a plant, if you have a manufacturing company and you have operations and someone has a safety complaint and they file it with OSHA. In the past, OSHA might come on site, the plant manager or your counsel will be with you while there's the walk around to see, to investigate, so to speak, the complaint. Now, under this rule, that employee, whether it's a bogus complaint or not, they're going to have a third party there with them. It's similar, and this is probably taking too much of a deep dive, but similar to, I guess, some of when you have an employee interview or a employee interview, and you can't have their counsel in the meeting with them, but they want to have a colleague that comes into the interview with them for the interview, just for their, I guess, protection. This is a similar situation. They get to have a non-lawyer representative, or they get to have a third-party representative walk around for the inspection as well. They do have to show good cause and a reasonable necessity for the third party to accompany the OSHA inspector. Based on what I've seen in dealing with OSHA, it's going to be hard for them not to find good cause. So it's I think that's going to be interesting to just follow this challenge by the U.S. Chamber of Commerce, and this is also filed in Texas. So just kind of be mindful, maybe watch it. The next slide is another union. Student athletes have been classified as employees. Now, this can be a hot button topic, quite frankly, with them get classified as employees and people working out such things. I think that people of my age and who have children that play PlayStation are excited because this means that NCAA football is coming back in about 2 weeks. And so I personally, selfishly, am happy solely for that. That said, as to the legal part of this, this has been ongoing since I guess late March, April, at least from the classification of the student athletes as employees. The fight has been going on for a long time, which is what caused the video game to be canceled for a couple of years. So there was a reason I brought it up. But the Dartmouth college basketball players challenged their status and filed with the NLRB. Well, first they created their own union, organized, and then they filed with the NLRB. And NLRB said, they are employees. Dartmouth controls them. They are performing a service. They generate substantial revenue. So they need employees, and so that's continuing to play its way out. Not only at Dartmouth, the NLRB, but across the entire landscape. And you can look at NIL, you can look at college football, reconferencing or redistricting, however you want to call it. All of this is kind of stemming from this argument or this fight that's been going on for years of whether these student athletes generating these large amounts of money for the schools and the NCAA were truly student athletes or employees or a hybrid. And so you can look at this and apply this to kind of some other issues and just look at it as the NLRB is taking a very expansive look on things and are really taking their enforcement power seriously. Obviously, that changes from president to president to however the House and Senate are controlled as well. But it has here within the past 4 to 6 years, they've been taking a very aggressive approach. And this is just more of it. And Katie, if you take the AI, because
Sure.
AI is important as well.
Yeah, so the ACLU has filed a complaint with both the FTC and the EEOC over AI hiring tools. And we've talked about this in the past. The EEOC had put out kind of some warnings and guidance on using AI in your hiring procedures. And sure enough, we're seeing some things filed, including these complaints. And so basically this complaint challenges 3 parts of the AI candidate interviewing process. So a personality assessment was done, a video interview was done with AI, so not with the person, and then a cognitive ability test. And so the ACLU is saying that this violates both Title VII, the ADA. It causes discrimination with those that are disabled and also with minority groups. And they're actually challenging it with the FTC, saying that these companies that are promoting these tools as being fair and efficient ways of hiring is actually misleading marketing. So we are seeing this come up. So this is just something to be aware of if you're using these types of tools. I would encourage you to go read that EEOC guidance or reach out to us. I'll be happy to send it to you, and really think through how you're using these tools and make sure that you are allowing people to request accommodations. So, if they are having trouble doing any of these cognitive tests or anything like that, make sure that there's a clear communication of who they can ask an accommodation from. So that's all I've got for that one.
All right.
I think this is you.
Yeah, we're going back to Starbucks, which I'm sure in real life no one minds. This is kind of this is back to Starbucks, back to unionization and private companies and Starbucks being involved in a suit with the National Labor Relations Board regarding the board's authority to get an injunction while unfair labor practices act a claim or charge is proceeding through the board's administrative process. This Starbucks Court versus Bikini stems from a 2022. There was a Starbucks, I think, in I don't know, was it Minnesota, Memphis maybe, and the baristas decided to unionize. In doing so, they decided to call the media and say, hey, come look at us. We're getting unionized. We want to have our rights, blah, blah. Media came, gave them the attention. Starbucks like, that's against policy. Y'all have to go. Y'all fired. Well, the charge was filed with the NLRB, and the NLRB sought to have an injunction. They filed in district court. And usually what had happened before this case was that the court would look at a two-step process. Basically, was there a reasonable cause to believe that there was unfair labor practices occurring or did occur? And if so, was the injunctive relief just and proper? Simple test, usually NLRB got, they would get their injunction. And what that would do is return everything to the status quo, i.e. those fired Starbucks workers who wanted to unionize, go back to work. Well, this case, which was decided by the Supreme Court and almost unanimous, said, not so fast. We need to go back to a traditional injunction test, which is a four-part test, which is basically the same here at our state court as well. But you need to look at the totality of the circumstances and the actual issue, which is a four-part test of are the people seeking the injunction likely to succeed on the merits? Are they likely to suffer irreparable harm without the injunction? You need to balance the equities of the parties. And then is the injunction in the public interest? In analyzing the Starbucks issue under the normal winter test, as they call it, the Supreme Court decided to vacate the district court's judgment and remand back to district court for adjudication. So the employees went back to being fired, and now the unfair labor practice charge is still proceeding through the National Labor Relations Board. All right. And I think the next thing we got, well, I don't want to get too much. Yeah, we kind of covered this. Basically, and just the short of it is that the National Labor Relations Board will not be able to get their injunctions as easy as they have been, because now the test is four-part and more balanced instead of the two-part test that leaned in favor of the board. Okay. And I think Katie will close out with our South Carolina updates.
Yes, and I wanted to, Denny Major, who's on our employment law team, he also had a follow-up on the question that we covered, that someone asked about their confidentiality provisions, and he brings up a good point that I wanted to share with everyone. He says if the items that are being protected in the confidentiality provision, if they are general / not really confidential, and they effectively prevent the employee from working for a competitor, then they'll be treated as a non-compete. If they are unique or unusual and are confidential and valuable to the employer, then the limitation should be okay. So you just want to make sure that the limitation isn't too vague, and it doesn't just like vaguely protect our procedures or something like that, because that can have a chilling effect. So I wanted to point that out. So yeah, send us those provisions. Let us take a look at them and see if they need to be less vague or dialed in a little bit. Okay, so I'll quickly hit on some South Carolina updates. There's really not much here. I would say that these items are kind of employer adjacent, so may not be as much of interest to the whole group, but in case they are, we wanted to share. So the South Carolina legislature just finished up a session in May, and so these are things that were adopted or signed into law by the governor as a result of this session. So one is that South Carolina has created this statewide education and workforce development office within SCDU. And this is an effort to really streamline all these workforce agencies and these, there's a lot of different like agencies and groups out there trying to fix this workforce issue that everyone is having. And so they've created this office under SCDU to streamline all of that and all of the efforts. So hopefully some good things will come out of that. The bill also mandates electronic filings for your quarterly wage reports if you have 10 or more employees, and any kind of information regarding a claim for benefits, unemployment benefits. So a lot of you are probably already filing those reports online, or your payroll provider is doing it for you. Just be aware that those are all moving to electronic filings. And I think if you're able to show some kind of hardship, SCDU may work with you, but just be aware of that. Act 136. So this disallows unemployment compensation tax to be paid at a reduced rate if the employer is delinquent on previous quarters, or if there's any unpaid or outstanding taxes that are due. And so, just be aware that that is now out there if you are delinquent on your taxes. Earned Wage Access Service Act. So this is really not something that affects employers directly, but if you are providing some kind of earned wage access, so these are services where the employee can get their pay early, or there's some different third parties that provide services like that. So South Carolina passed an act that really establishes a framework for those earned wage access service providers to operate under. They have to register with the Department of Consumer Affairs. So, and there's some other restrictions in there for them, but this is just something to be aware of as you're using these third-party services, that a lot of states are really starting to provide frameworks and kind of, I wouldn't say crack down, but they're much more aware that these services are out there, and there's a lot of wage and hour issues that can come up in that as well. So that just be aware that that's out there. Okay, next slide. South Carolina did approve an apprentice tax credit. If you have an apprentice through the Office of Apprenticeship, and if you enter into an agreement with them, there is a tax credit that is now available, $1,000 for each apprentice employed, not to exceed $4,000 or $6,000. So just be aware that that's also an opportunity that's out there as well. And okay, actually, I think I already talked about that. So maybe a typo, and just again, the Earned Wage Services Act. So I think that's all. I don't think we had any more questions pop up. I've kind of been watching the chat. So we are taking the month of July off. I know a lot of people are out on vacation, so we won't have a webinar for the month of July. We will be back in August. So just be on the lookout from our team about our topic for August. And Joseph, anything else?
Again, thank you for spending your lunch hour with us. Those are our accurate pictures. So if you need anything or have any questions that you didn't want to submit here during the webinar, feel free to send us an email, give us a call. We'll be happy to assist. Hope you have an enjoyable rest of your Thursday. We're almost there, people.
Thanks, everyone.
Bye.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.